So, Judge, there's a document style memorialization of proffer regarding testimony above the love sponge plan, the formal content of which has been agreed to by the parties. And I imagine, Mr. Rice here. I don't know, it didn't look like there were signatures, it looks like electronic signatures were done on it.
Right, what we thought that we would do, Your Honor, is just to make the record clear, we would read this into the record. Both parties have signed it. Mr. O'Brien would then put on the record that he is on board with this and that his client will take the fifth, and then Your Honor would accept it or not.
Okay. So you're going to give me a copy, or you're just reading it, or what?
We can give you a copy and I'll read it as we go.
Approach.
So, Your Honor, as Mr. Turkel said, this is a document that's titled Memorialization of Proffer Regarding Testimony of Bubba the Love Sponge Clem. And it begins, in response to the court's oral ruling on May 14, 2016, plaintiff Terry Jean Balea, defendants Gawker Media, LLC, Nick Denton and A.J. Delario, and non-party witness Bubba the Love Sponge Clem hereby memorialize the following, including the proffer recited below, and state as follows. Defendants Gawker Media, LLC, Nick Denton, and A.J. Delario issued a trial subpoena to Bubba the Love Sponge Clem. Bubba the Love Sponge Clem moved to quash the subpoena. In an oral ruling on March 14, 2016, the court granted the motion but authorized defendants to create a record of the topics on which they had hoped to examine Mr. Clem and directed Mr. Clem to appear on March 16, 2016 to do so. Subsequently, counsel for defendants provided counsel for Mr. Clem and counsel for plaintiff with the following list of topics on which they would, if they have been permitted, question Mr. Clem at trial. Mr. Clem's counsel advised that Mr. Clem intended to invoke his Fifth Amendment right against self-incrimination in connection with all such topics and agreed to appear on Mr. Clem's behalf to confirm that invocation to the court on March 16, 2016. The topics including illustrative questions on which defendants would, if permitted, examine Mr. Clem are as follows. A, Mr. Clem's relationship with plaintiff, including whether they have shared secrets that they will literally take to their graves and whether they would do anything for each other or each other's family. B, plaintiff's relationship with and knowledge of Heather Cole, formerly known as Heather Clem, including whether Mr. Clem told plaintiff that Ms. Cole's encounters with other men were filmed, whether plaintiff approached Mr. Clem because he wanted to have sex with Ms. Cole, and whether Ms. Cole approached plaintiff about having sex with her. C, cameras in the Clem's house that filmed plaintiff and Ms. Cole, including whether plaintiff knew he was being recorded during his sexual encounter with Ms. Cole, whether Ms. Cole knew that she was being recorded during that encounter, whether Mr. Clem held onto the tape for years, whether others knew about Mr. Clem's practice of recording, and whether others knew about the tape of plaintiff and Ms. Cole having sex. D, Mr. Clem's interactions with plaintiff and plaintiff's counsel, David Houston, including whether they ever threatened to prosecute Mr. Clem for a crime, and whether he is concerned that they will seek to prosecute him for a crime or cooperate in any such prosecution. E, Mr. Clem's interactions, or lack thereof, with Gawker, including to confirm that after Gawker published the video excerpts at issue in this case, he did not contact or complain to Gawker. F, Mr. Clem's meeting with the FBI, including to confirm whether he told the FBI that he, Ms. Cole, and plaintiff all knew plaintiff's sexual encounter with Ms. Cole was being recorded. G, the sex lives of public figures generally, and the sex life of plaintiff in particular, including whether plaintiff's sex life has become a matter of public concern, whether plaintiff was appearing as Terry Bollea or Hulk Hogan, or some combination, when he appeared on Mr. Clem's radio program, to confirm that Mr. Clem only asks some guests questions about their sex lives, depending on the person and the circumstances, to confirm that Mr. Clem and plaintiff discussed plaintiff's sex life on Mr. Clem's radio program, and to confirm that shortly before Mr. Clem and Ms. Cole were married, he broadcast a parody on his radio show about a fake sexual encounter involving the two of them and plaintiff, and whether he thought that topic would be appropriate to joke about on his radio program. H, Mr. Clem's connection to Vivid Entertainment through Bubba Raw, including to confirm that Bubba Raw shows women engaging in sex acts and that Bubba Raw DVDs are sold by Vivid. I, plaintiff's motives to, quote, work a sex tape, including that by 2012, plaintiff's earning capacity had diminished, that plaintiff was worried about running out of money, that plaintiff needed to reinvent himself following his divorce, that Mr. Clem thought plaintiff was, quote, damaged goods, that Mr. Clem advised plaintiff not to talk about the sex tape, that plaintiff was trying to make this a public spectacle, that Mr. Clem thought plaintiff's lawyer, David Houston, was trying to stay in the media, that plaintiff and Mr. Clem had discussed making a sex tape to get plaintiff money, and that Mr. Clem does not know whether plaintiff had anything to do with providing the sex tape to TMZ, The Dirty, or Gawker. J, plaintiff's practice of handling scandals, including that plaintiff has a reputation for using the Hulk Hogan character and persona to dodge public scandals dishonestly, and that Mr. Clem publicly described him as, quote, the ultimate lying, working showman. Next paragraph. Counsel for Mr. Clem has advised that his client will invoke his Fifth Amendment right against self-incrimination in connection with each of the foregoing topics and questions concerning those topics. Based on that representation, defendants will agree that counsel for Mr. Clem may appear in court in person on March 16, 2016, and may do so on behalf of Mr. Clem. Defendants' agreement is not intended to be, and shall not be deemed to be, a waiver of their position that Mr. Clem be required to appear in court to provide substantive answers with respect to each of these topics, or, in the alternative, that he be required to assert his Fifth Amendment rights in front of the jury, and/or that the jury be informed of the circumstances of Mr. Clem's failure to appear before it to give testimony. Plaintiff preserves all objections to questions relating to each of the foregoing proffered topics were they to be asked at trial, and preserves all objections to any documents that defendants would seek to admit in connection therewith or that are identified herein. Were defendants permitted to question Mr. Clem, plaintiff expressly preserves his right to question Mr. Clem as well, including, without limitation, concerning his statements to the Tampa Police Department, including, without limitation, to confirm that plaintiff did not know that plaintiff's sexual encounters with Ms. Cole was or were being recorded. Plaintiff also expressly reserves his right to question Mr. Clem and to elicit testimony as reflected in his deposition taken on March 3rd and 4th, 2014. Defendants expressly preserve all objections to such questions by plaintiff and preserve all objections to documents plaintiff would seek to admit in connection therewith. Based on this court's ruling, neither plaintiff nor defendants will seek to introduce Mr. Clem's prior statements concerning the above, including, without limitation, his deposition testimony, his statement to the FBI, and/or his statement to the Tampa Police Department. Plaintiff agrees that defendants would call a witness from the FBI who would be able to authenticate records produced by the FBI pursuant to Gawker's Freedom of Information Act request, or would stipulate to the authenticity of such records, but will not require defendants to do so because the court has ruled such documents inadmissible. It's dated today's date, March 16th, and has been signed by counsel for both plaintiff and defendants. And I believe Mr. O'Brien is here to represent that Mr. Clem would in fact assert the Fifth Amendment in response to each of those topics.
Thank you, Mr. O'Brien.
That's correct, Judge. I have gone over this document with Mr. Clem. Mr. Clem asserts his Fifth Amendment privilege at this point.
Nothing from the public, Judge.
Nothing further, Your Honor.
Thank you. Thank you very much, Mr. O'Brien.
May I be excused?
All right, so tomorrow, you have some further deposition designations that your exhibits in. Okay, so can we work on some jury instructions now?
Yes, sir. Just so that the record is clear with respect to the issue of Mr. Clem, the subpoena remains quashed.
Yes.
Thank you.
Yeah, probably for clarity, Judge, we'll probably go ahead and submit a written order. Just do a simple memorialize that.
Yeah, that makes sense. Just want to make sure the record is clear.
Anything else on that?
No.
Well, there's another issue with respect to Mr. Clem's appearance or lack thereof at the trial. And we can either take that up now or in connection with the discussion we're about to have on jury instructions.
Is this the issue related to the jury instructions they've submitted on this?
Yeah, that's
So we can talk about when we talk about jury instructions.
sounds like a plan.
I think that's what we're going to do next.
Right. So I don't consider it a separate issue. I consider it part of that issue.
I stand corrected.
Mr. Sankey, do you have a trial?
I do, Your Honor. May I approach? So what I have here is the set of jury instructions that you read part of the first day of trial. And it starts here at 18, which is where it was left off. And then yes, except for I flagged 3 issues where we want changes. So that's what I would like to talk about. And Mr. Bode has a copy of this as well. So, Your Honor, there are only sort of 3 issues we have at this point. Just to be clear on the record, we initially objected to a number of these instructions. That was ruled on. We're preserving those objections. Our first issue is with respect to instruction number 24. And that should...
The first flag is number 19.
Oh, really?
Oh, yeah, versus flags on.
It should be 24.
Okay, yeah.
Did I get it right?
Yes.
Yes, excellent. Page 50, instruction number 24. This is the instruction for invasion of privacy based on right of publicity. And what we want here, Your Honor, is just 2 additional sentences defining for the jury the concept of a commercial or advertising purpose. When we discussed this, I think 3 weeks ago, we had a very long instruction. It had clauses. It had, these twisty phrases. And Mr. Turkel objected, perhaps appropriately, that it was too long. It might confuse the jury. I didn't understand at that time that we actually had a disagreement about the law. The law is pretty clear on this. That's the Tyne decision. That's the Loft decision. So we want the following instruction. I'd like to read it into the record, if I may. So the instruction as written is as follows. The issues for you to decide on plaintiff's claim for invasion of privacy based on common law right of publicity are 1, whether defendants in posting the video on Gawker.com used plaintiff's name or likeness for a commercial or advertising purpose, and if so, whether plaintiff gave his consent to defendants to use his image or likeness. And what we would want is the following language that I'm about to read. I will now define some of these terms for you. Using another's name or image for a commercial or advertising purpose means using the name or image to directly promote a product or service other than the publication in which the name or image is used. In other words, to find that the defendants used plaintiff's name or likeness for a commercial or advertising purpose, you must find that his name or likeness was used to promote something other than the defendant's own publication. And the Tyne decision and the Locke decision, it's not a direct quote, but it's completely in sync with those decisions. We had a bench memorandum on this subject earlier. So why don't we hear a response?
I don't think the definition is necessary for the same reasons that we addressed before. I got this much time today. I don't know if this is out of those cases. I know there are other cases that define it differently. The fact that it's not a direct quote, I think very problematic. And I think the instructions on the 2 points that are above speak for themselves.
I would submit, Your Honor, that the term commercial or advertising purpose is a legal term of art. It's not a layperson's term. It needs to be explained to the jury. And if you look at the next instruction, Your Honor, instruction number 25, this is issues on intentional infliction of emotional distress. You go through the elements, and then there's a very long, about almost a whole page, explanation of the various legal terms. And I think that's appropriate, and this is accurate. I have no dispute with it. Yeah, those are part of the standard instructions, and I have no dispute with that. But if you're going to define these terms, which I don't think are terribly obscure, I think you also need to define commercial or advertising purpose. And I am not aware of any case in Florida, federal case interpreting Florida law or Florida state case, that says anything but that commercial purpose in this context means promoting a product or service distinct from the publication itself. The Supreme Court of Florida established that in the Tyne decision. The Loft decision, which Tyne adopted and followed, sets that out. There's no dispute. I have not seen a single case that differs at all on that point of law. Whether they use these precise words or not, I can't represent to you right now. But there's no case that I'm aware of in Florida or interpreting Florida law that says anything but commercial purpose in this context means to promote a product or service other than the publication itself. That's black letter law, Your Honor. Number 31, Your Honor. So for this one, we have proposed a new damages instruction, and I'll give you what is presently in the instruction. Right, it's useful for So that what I think is there is the instruction that is presently in. So the damages instruction number 31 that is presently in the set that you had read at the beginning of the trial. Okay, good. So, Your Honor, we have suggested or proposed essentially 2 changes to the damages instruction. The first change is that we want, and we discussed this, I think, 2 weeks ago, we would like a nominal damages instruction. We want the jury to be informed that if they find that there was a violation of Mr. Blair's right to privacy, but they find that he suffered no, or hasn't proved any emotional distress damages, that they can award nominal damages if they want to vindicate his right to privacy. That's the first point, and that's the second paragraph of the instruction, which reads, if you find for plaintiff on his claim for publication of private facts and or intrusion upon seclusion, but find that no such damages have been proved, you may award nominal damages. Have been proved, you may award nominal damages. Nominal damages are damages of an inconsequential amount, which are awarded to vindicate a right where wrong is established but no damage is proved. And we submitted a bench memorandum on this, Your Honor, and I think the law is clear that that's available as a class of damages here. The second thing we've done here, and this is paragraph 2, if you look at the original instruction that was submitted, and this is plaintiff's language, for economic damages, they give you an A, an amount of money which the greater weight of the evidence shows will fairly and adequately compensate plaintiff for the total benefit the defendants receive from posting the video of plaintiff on Gawker.com, and a B, an amount of money which the greater weight of the evidence shows will fairly and adequately compensate plaintiff as a reasonable fee for people viewing the video of him naked and engaged in consensual sexual activity on the internet. What we've done here is just provide the jury with a general category of economic damages. We think that's more appropriate than providing the jury with plaintiff's particular theories of economic damages. We just want to sort of give them that general category. And the other point to make in this honor, the other point to make on this issue, Your Honor, is that the way this is laid out here, the implication is that they can award both of these damages, but that's not true. Right? These are alternate theories of plaintiff's right of publicity damages. He can't get both. Either his publicity rights are measured this way, or they're measured that way, or as we suggest, they're measured some other way. But he can't do both. So we think the fair thing to do, what makes the most sense and to avoid double recovery, is just to have a general class, a general category in the instruction that says economic damages. And in their close, they can explain to the jury their theory of what the economic damages here are. And that's our position on that instruction, Your Honor.
And Your Honor, they said there's 2 changes. This has been completely rewritten. These side by side.
There are 2 substantive changes.
I don't know where that came from, but I had to read this thing 3 times before I even started to make sense of it. I know I'm tired, but I mean, I have a little more knowledge of this area than the jury's going to. It's extraordinarily confusing. They split in between different causes of action, claims, some here, some there. You know, economic damages, I'm not even sure what that is. We're suing for compensatory. And it's the ones that we have talked about fairly and adequately compensating. I disagree with the contention that we're only entitled to items A and B under our right to publicity. I think those elements are recoverable. I think those elements are recoverable under the other causes of action. And we don't want a nominal damages instruction for the plaintiff. So I think the damages instruction we have number 34 is simple, it's clear, it's to the point, and it directly tracks the evidence that was heard during this trial.
Anything else, Mr. Staples?
One moment, Your Honor.
The last one then, which is on page 65, is the flag. It is jury instruction 34 on punitive damages by the plaintiff.
Right, and here I think I've circled the paragraph on your version. There should be a paragraph on page 65. Bracketed, sorry. That begins your determination. And what we've done here, this is the standard punitive damages instruction. We can see that. When we were here 2 weeks ago, we were discussing in the context of plaintiff's demonstrative certain evidence that we internally refer to as prior bad act evidence of other Gawker stories which they claim are similar and shed some light on this event. We claim they're not similar and shed no light. We mostly lost that issue. In arguing the other side, what Mr. Turkel said is, this is Williams evidence, which made a light bulb went off in my head. I said, aha, if Williams evidence gets in, we want a Williams instruction. And that's what this is. Somewhere in the punitive damages instruction, we want the following language. Your determination to award punitive damages to plaintiff must be based on actual harm suffered by him. You may not punish defendants for harm suffered by anyone else. When determining the amount, if any, of punitive damages to be awarded, you may not impose punitive damages to punish a defendant for harms caused to others whose cases are not before you. We think that follows straightforwardly from the fact that they got Williams evidence in. That's our position, Your Honor.
Judge, for the benefit of Mr. Safer, the record's Williams rule evidence, not Williams evidence. Both sides got Williams rule evidence in. We debated for days, months over Williams rule evidence, and he's modifying the standard instruction. And the Supreme Court has told this court that if it follows a standard, it can never be reversed on that standard. So, and it seems like they made it up based on Williams rule evidence coming in, which I think
Anything else?
I just think it's perfectly appropriate. I mean, they've been permitted to put on evidence about other people who are upset about things Gawker's done. That is potentially highly confusing for a jury and highly prejudicial for us. We think this goes some way toward curing that. That's our issue, Your Honor. Even if it's not reversible error to depart from the standard instruction, that doesn't mean you can't do it if it's a good idea. And I think it's a very good idea here.
Okay, so here's what I'm going to do as far as those 3 issues is take all these bench memos that you give me before, pull it back out, go through it all again, and so over the course of the evening, we're a little more fresh. We'll be through it, and I'll give you the rulings tomorrow morning. copy of those jury instructions and go on there.
I appreciate that, Your Honor.
Did you have your finger up?
It is. We have one other. Are you?
I had to
Oh, so we're off the jury instructions?
Yes, ma'am.
Okay, well, let's finish while we're on the jury.
Oh, no, it is. I'm sorry.
Oh, it
I thought you
is?
said, is it about jury
Oh, I
instructions?
know what you meant. Okay, go ahead.
Oh, yeah. Indeed it is. It's just trying to close the loop on this business with Bubba the Love Sponge. And let me give you the copy. This is an instruction to deal with.
So, unavailability?
Yes, ma'am. So we had thought, it had seemed to us that given the time and the effort that these folks sitting on that jury have invested in this matter, that they should know something. And so we put this together, pretty simple, saying, as you are aware from the many bench conferences we've had in this case, sometimes developments happen outside of the eyes of the jury. I want to inform you about one involving Bubba the Love Sponge Clem. Defendants Gawker Media, LLC, Nick Denton, and A.J. Delario subpoenaed Mr. Clem to testify in their case. However, he is unavailable to testify. We originally had put in language about he invoked the Fifth, but we went back and forth on that, and we said this would be so that they would know that. They've got to be sitting there asking them, scratching their heads and saying, what the heck? And I think they're entitled to that.
Clearly, I have many questions about it, but I wouldn't be calling you about the love sponge. Anything else? Anything else?
Judge, I reviewed, they gave us these two instructions, notwithstanding the fact I hate the first two sentences about we've had a lot of bench conferences, because that tells them that the only important bench conference is the one you're now going to mention and instruct them on. The favor case that is the case on which Guzman is predicated provided notes parenthetically in court in the last paragraph, notes as follows. If counsel had requested a jury instruction stating that Van Drake, who was the invoking witness in that case, the invoking third-party witness, was not available to either side as a witness and that the jury should draw no inference from his absence, such an instruction would have been proper. So our district courts have said, if you're going to do something, that's what you should do. The response I got originally from the defense was, well, we subpoenaed him. But the truth is, the minute he became unavailable, by invoking, we had a right to put his deposition in, and for the ease of this entire exercise, so they could read this 5-page stipulation into the record, we agreed not to put his deposition in, knowing full well what it says. The point is, if we're going to instruct him, we should be telling him you can't draw an inference as the other side on this. We're not instructing at all. And I'll leave it to you on that, Judge. I don't know that the instructions needed they've asked for. You know, I do know if there is an instruction to be given, we have a case that kind of says what it should be. So. We had no inclination, no desire, we didn't think there was any need to instruct them at all. This is something they proposed. So what I'm saying is, if you're going to instruct them, this case says generally, it wasn't given in that case, so it's just the court saying this is what it should say if you're going to do it. I don't think right now, given the way the record's developed in this case, that they should be instructed specifically on Mr. Clem in any respect. So.
And as you know, I strongly feel that they're owed some explanation. I think they're owed that.
find a copy as favor, Judge?
You're basically looking at the paragraph right before it says affirm.
Right, and where the court says we note parenthetically that if they had asked for instruction, I think it's completely in your discretion whether to give one or not, Judge. It's hardly a conventional situation, but if we are going to give one, the VCAs have told us what it should say.
So it looks like there would be, in addition to, or as part of the instruction, it basically adds such an, it says, the jury should draw no inference from his absence. Basically, some kind of addition to.
Right. The argument that we don't really get into.
So it would basically say he was not available to either side as a witness and that the jury should draw no inference from his absence.
Right, and where we had disagreed when I spoke to Mr. Gray and Mr. Sullivan was when we subpoenaed him. The minute he invokes he's unavailable under 804, we had the right to put his depo in at that point. We chose not to. We all stipulated nobody would do that. So we, it becomes available to nobody. That's how it went.
Mr. Sullivan, you have any objection to that? And I really think you all have done a good job to not have many bench conferences. So I wouldn't want to say many bench conferences because we
with all
good job not to.
with all due respect to whoever scripted it, that whole part I think is
Yeah.
not good. So
I thought you made a good point.
Especially the tobacco cases, the CBN reports, most of it is blotted out. So
Right. We would just ask that if the court finds it necessary to instruct, or that's ultimately where you want to go with it, that it track that language stating that Mr. Clem was not available to either side as a witness and that the jury should draw no inference from his absence. The court tells us that would have been proper. I think that's about as clean as it can get. So, yes. Yeah.
Yeah, exactly. Your Honor, the one point I think that should remain is still that the defendants, Gawker Media, you can just say the defendants, subpoenaed Mr. Clem to testify in the case. He was determined to be unavailable, say to either party, whatever, but I think that point that we did in fact call this fellow is appropriate to be noted in the instruction.
Yeah, Judge, we don't. We think you should follow the language of the case because the whole idea of this is that people don't strategically try and set up inferences to be drawn from someone invoking. Because once he invokes, he's unavailable, and we would have put his deposition in with all his sworn testimony that my client didn't know, and that he was sorry for any time he said it, and then they would have put their documents on it, we would have, and we all just stipulated to avoid that by agreeing that nobody was going to do anything. Thus, not available to either side. Thus in accord with favor. So I get what they want to do.
We had Todd Clem as well as the Love Sponge Clem is not available to either side as a witness, and that the jury should draw no inference from his absence.
His name is actually legally, I believe, Bubba.
It is.
Change his name to that.
You could call him Mr. Clem or...
I don't know that it would be appropriate to call him Mr. Clem.
Yeah,
Of all the people.
I've never dealt with a nickname that became a legal name in court before, so whatever the court thinks is proper there.
So is there any objection to that?
No, Your Honor.
But I don't really see that being included in the official written instructions that all the jurors get. You're saying they just to announce that tomorrow, correct?
I think it is.
I don't know if they talk about it if it was a curative or...
I think it's just an instruction I give them, just as an
Yeah.
instruction that you would give somebody, now you're going to see the deposition taken on such and such a day, those kind of instructions.
I see.
Curative. I think that's fine.
Okay, so the court then will give that instruction tomorrow.
All right.
Okay, and so anything else on the jury instructions?
No, ma'am.
Okay, so it would be my thought that typically, when you're reading the instructions before and after, you don't, there are a few of the instructions from the beginning that you don't reread. So, So does everybody have their initial instructions from? So I think, Mr. Savior, I think you took all those already, right?
Yes.
Okay. The problem, the only big difference then that I see is the index still includes them all. So we're
Right.
probably just not include the index at all in our copy. And we're going to make them now one per page because we're making so many multiple copies. We'll stitch them all together.
Right. And just so I'm clear, it starts at 18, right?
Yes. Yes. I see what you did, okay, I'm following you, I was just looking at the index. Okay. And that. All right, so can you do me a favor, Mr. Savior, and email these then to Teresa? And then tomorrow, so that we can work on them and
Absolutely.
consolidate them or shrink them down.
And you have what I proposed to you that you're going to think about tonight and sort of make a decision. And then what I'll send to Teresa is exactly what you had at the beginning of trial minus 117.
If you could just email her just what you handed me just a few minutes ago.
But that includes our proposal. Just here. Okay.
I've got it on my flags, because then I'll mark this one up one way or the other, and then I'll just throw it in the morning.
Understood, Your Honor.
And then that way we can have them all copied. How about a verdict form?
Can I speak to Mr. Vogt for a second?
Yes.
On the verdict form, I just gave this to Mr. Vogt at the lunch recess. He has not had a full chance to review completely our new proposed verdict form. He thinks we're probably very, very close. Would it be possible to button this up early in the morning tomorrow?
Rip stitch? Yes. That's
Perfect.
fine. Can you give me a copy of it too?
Absolutely. Make sure it's not the one I wrote on.
So that's okay.
You don't know what I wrote? Okay. Good, Your Honor. It was not that jury.
Judge, this was ours.
This is your Mr. Vogt, you're going to look at them over the course of the evening
Yes.
at theirs, and then we'll talk about them all, both of them tomorrow.
Yes. And if we start to reach agreement on some of the points, we'll try to modify at least what we agree on, and then we'll email that to Teresa as well, so she has it.
What, over the course of the evening?
Yes.
Okay. Anything else that we can handle tonight? I'm sorry, I'm looking for all my minutes. Anything else?
No, I think we're good.
So, Your Honor.
All right, so great. Can we then convene tomorrow by 8:30?
8:30?
Jackie Street.
Yeah, what the heck, I'm still.